welcome. We're glad you're here with us today. This is the nuts and bolts of retention, which is episode 2 of the second series of Financial Poises, the nuts and bolts of chapter 11. You can read more about this series on slides 7 through 9. Our panelists today are in alphabetical order: Matt Christensen of Johnson May, Doug Floud of Echo Park Legal, and John Friedland of Much Shields. I'm Matt Grimshaw. You can see our names on slide 6 and our bios on slides 34 through 37. This is not an infomercial. I'm not going to read you our bios. You're capable of doing so if you'd like to. Before we begin, we have a few housekeeping matters. First, I'll try to call your attention to slides that are relevant to what we're discussing so you can take notes if you want to. If you're listening but not looking at the slides, don't worry. The slides aren't critical to what we're going to be discussing. Second, a big thank you to our co-sponsors, our co-producers, the National Law Review and Daily DAC. You can read more about them at the beginning of our slide deck. Also, Financial Poises webinars are supported by sponsors. The sponsor for today's webinar is Max Asset. You can read more about Max Asset on slide 4. Finally, the last housekeeping matter is a disclaimer. Although we are all lawyers, we are not your lawyer. You are not our clients, and what we offer today is information for your general education. Nothing we say here today is intended to be acted upon without you doing your own due diligence, including obtaining appropriate advice from someone that does in fact represent you. Without further ado, let's just jump right in. John, why do we have this webinar? I mean, in law school, we're taught that you get an engagement letter signed by a client and you're off to the races. Why is there more in a Chapter 11?
Because, Matt, bankruptcy is kind of a world unto itself. Chapter 11, in a Chapter 11, the debtor becomes a debtor in possession, which effectively means the debtor's wearing two hats. It's still what it was. It's still the business, but it's also now a fiduciary for its bankruptcy estate. And that dual role triggers requirements that go far beyond what's required under the ethical rules of any of the 50 states. And there are, very specific bankruptcy code provisions and bankruptcy rules that have to be satisfied, and a court has to decide that they've been satisfied.
Are there more people that wear multiple hats in a Chapter 11? I mean, for example.
Oh, sure. That's a leading question. Thank you. I know where you want me to go.
I'm not good at much, but that I can pull off.
So the other a baseline distinguishing factor between a bankruptcy case on the one hand and any sort of most civil litigation is that in most civil litigation you've got two sides, plaintiff and defendant. You might have multiple plaintiffs, you might have multiple defendants, but there's sort of just two sides, with some caveats that I won't get into. In a bankruptcy case, by definition, you've got a lot more than two sides. You have the debtor, the company that filed bankruptcy, or in an involuntary that was put into bankruptcy. You've got a senior secured creditor and perhaps other secured creditors, each of whom have their own particular interests at heart. You have general unsecured creditors, right? And in some ways, they're all aligned and they're on the same side, but in other ways, they're all different from each other. And I could go on, but there's, and then, the best example would be the Office of the United States Trustee, which is by definition a party in interest in every single Chapter 11. So yeah, it's a multi-party thing, as opposed to usually what you have is a two-party thing outside of bankruptcy.
With duties running to everybody. All right. Matt, two sections deal with employment in a bankruptcy case, in a Chapter 11 case. How about we start with section 327, which deals with the employment of, I believe the term is, quote, professional persons. And if you, for those that are viewing this, if you're interested, it's slides 11 through 13. Matt, how about you walk us through who has to get employed and how that works?
So under 327, which is applicable in Chapter 11 cases, there's provision of Chapter 11 that says they can hire professionals just like a trustee can. So the language in 327 talks about a trustee hiring people. But generally, there's a list of specifics. So attorneys, accountants, appraisers, auctioneers. So those are obviously covered by them. And then other professional persons is the last phrase that's used. So if you're an appraiser, auctioneer, accountant, or attorney, I think Congress just got sick of the list after the A's and stopped there and said professional persons will just fill in for everybody that doesn't start with an A. Then you're covered by the thing. And so the issue that sometimes comes up is, well, I'm not one of those four. Am I still a professional person? Do I need to get employed in order to assist the debtor? There are some sort of clear yeses. So in a Chapter 11 case, a lot of times the debtor will hire a financial advisor of some kind. That person needs to be employed. But I did have a case we were involved in where the debtor had hired essentially a financial advisor, but they were treated more like a CFO within the company. So they were paid a 1099 payment, but they didn't do any application to employ them. They were hired, they worked for the debtor prior to the bankruptcy case and afterwards. In the Chapter 11 timeframe, the U.S. trustee took the position that they did not need to do an application to employ them because they were essentially a CFO type for the company. Later, a Chapter 11 trustee got appointed and then pursued an adversary case against this guy for a bunch of things, but one of which was, hey, you were never employed, and so all these payments you received post petition you have to return because you weren't employed. And part of our defense was he never had to be employed. In fact, the U.S. trustee agreed he never had to be employed. And so there's always that risk. If you are a professional person and you choose not to do the application to employ you, maybe at some point the judge decides you are a professional person that needed to be employed, and therefore you got to give all your compensation back. So
So,
that's an issue.
and I know that is something we're going to touch on in a minute. One of the things you mentioned, Matt, is that somebody's got to be disinterested to be employed. What does that mean?
So there's really two requirements outside of what you are. You have to not hold or represent an interest adverse to the estate. So in other words, if I'm a creditor and I'm owed a ton of money by the debtor, I have an interest adverse to the estate. There's a small exception to that we'll get into later. And then I also have to be disinterested. Or the phrase that always hangs me up is I'm not disinterested, which to me sounds like a double negative, and I have to think through that before I actually realize what I'm saying. So disinterested is an actual defined term in the code that basically you're not a creditor or an insider or weren't an insider of the debtor within 2 years of the petition, and you don't have an interest materially adverse to the interests of the estate. So to a certain extent, it's sort of circular. I have to not represent an interest adverse to the estate, and I have to be disinterested, which means I don't represent an interest adverse to the estate. So essentially, if I have any tie to the debtor, there's going to be some question about whether I'm disinterested, and I need to work through that.
So it's all about connections.
Connections.
Doug, if we look at slide 15, companies in financial distress are often in litigation. When attorneys representing a debtor pre-bankruptcy, are around, can they still be involved? I mean, they've got a connection like Matt was just talking about with the debtor. They were working beforehand.
Yeah, well, let's kind of unpack that question a little bit. I think I know where you're going, and that is that there is an express exception for a trustee to employ somebody who is not disinterested, and that's going to be 327E, and that's an interesting provision because 327 applies to all professional persons, if you will, right? But 327E, the exception, only applies to attorneys. And certainly there's been situations where the debtor wants to, or the trustee wants to employ the debtor's former sort of financial advisor or other professional person, and they can't rely on Section 327E. But let's back up a little bit in the sense that every professional in every Chapter 11 case, right? You have a team of professionals, often someone like you, Matt, or myself, may have some financial advisors, and we don't file Chapter 11 on a whim. We prepare, and then file Chapter 11. So the debtor, before it files its voluntary petition in Chapter 11, already has its team of professionals, right? And if you read just the plain language of Section 327, you would say, well, that's going to be a problem, right? We understand that 327 says trustee, but that can also be a debtor in possession, but through the definitions. But how can a debtor in possession say that the law firm or the accounting firm has no connection to the debtor if in fact they represented the debtor pre-petition and prepared the debtor to file the bankruptcy case, right?
So there's a
Well,
connection. Yeah.
so there's obviously a connection. Well, that's answered in Chapter 11. It's a specific Chapter 11 provision that really only applies to Chapter 11, and that's Section 1107, which expressly says that any person can represent a debtor under 327. So it's like a further exception to 327 that's not written in 327. It's written in 1107, that this person, professional, can represent a debtor even if they represented the debtor pre-petition. So in Chapter 11, where you have a debtor in possession, they can effectively employ their whole team of professionals post-petition as long as they file their employment application that we're talking about now, and they're otherwise disinterested. But they're not going to be disqualified just because they represented the debtor pre-petition. Now,
Is that
what
is that true for litigation folks too, not just the ones that are going to be handling the bankruptcy?
For a debtor in possession, yes, I believe that would be true for that. Now, for special litigation counsel under 327E, that's an even broader exception, and that would apply even if a Chapter 11 trustee was appointed, or if, God forbid, a Chapter 11 case was converted to Chapter 7. And what 327E says in practical terms is it says, look, we recognize that there may be someone that knows that's the perfect person to do this litigation or to do whatever it is, but that they may not be totally disinterested. And the typical in a Chapter 11 where it's a debtor in possession, the typical situation is that somebody represented the debtor and ran up a large legal bill, right? Hundreds of thousands of dollars. The debtor owes them. The debtor doesn't have the money to pay them, which, if you're owed money by a debtor, with some exceptions in subchapter 5, you cannot represent the Chapter 11 debtor after they file. And the way we handle it as debtors lawyers, we get a big retainer, we draw it down right before we file the petition, and then we file the petition, and we can tell the court that we're not owed any money. Well, if you're litigation counsel, you're ran up a big bill, and the debtor simply doesn't have the money to pay you, right? Without 327E, you would not be allowed to represent the debtor, which means that all the institutional knowledge and the knowledge that you built up that make you the perfect person to continue to prosecute this case or litigate this litigation after the filing would be lost. So 327E allows a law firm or a professional that is owed money. That's usually the issue that would make them not disinterested, to represent the debtor. But they can't be the main decision maker. There has to be disinterested general bankruptcy counsel that's making the decisions going forward, and running the case. But the 327E is just an exception for typically special litigation counsel, and that's what you call them. You file the application, you disclose that they ran up a huge bill pre-petition and that they are a creditor of the estate, but that they're the best people to handle this litigation and they can be approved.
Okay, so
I
they,
just want to, if I could just overlay one thing
please.
was that it's not only with respect to litigation counsel. I mean, you could have 327E transactional counsel too.
And
Absolutely.
John, you read my mind, because that was going to be what I asked was, okay, I mean, intellectual property ends up being a really big one oftentimes, or, other sorts of transactional counsel. They've had general corporate counsel for years. And that's the sort of one that you can still get them in under that same guise, can't you, Doug? Or
Yeah,
John, one of the
absolutely.
two
I
of
think
you?
where you see that being less of a problem, although it can be, and 327E does not distinguish between litigation or intellectual property or general counsel, corporate counsel, what have you. But the reason it often is mostly in practice litigation firms that use 327E to get in is that if you're paying, you say you have an intellectual property lawyer that you pay, $5,000 a month to maintain your intellectual property portfolio, typically they're paid current. And as long as they're paid current, there is no problem with them representing the debtor. They can either be an ordinary course professional, which doesn't need disinterested necessarily either, or they can just file an employment application and they say they're disinterested. Sure, they represented the debtor, but they were not owed any money pre-petition. So usually, a lot of times, you don't see them owed substantial sums pre-petition, or they agree to waive that pre-petition amount. When for better or for worse, litigation is what runs up the big bills, and often bankruptcies are filed sort of right before trial or right after trial, and so there's a say what six-figure bill, and the firm's not willing to waive that, and the debtor doesn't have the money to pay it, and so you have to figure out how you're going to employ that law firm, and it's 327E.
All right. So, John, a few minutes ago, I mentioned that there were two bankruptcy code sections that kind of deal with employment. I think we started with 327, and 328 ends up being the other one. Could you talk to us for a minute about the 328 process and how it differs, if at all, from 327, and what is required?
The process is very similar. The key difference is that the 328A application allows the retention of the professional on specific terms, specific financial terms approved in advance by the court, contingency fee arrangements, for example. So the court pre-approves them, and then later, when fee applications are filed and people might want to object, the financial terms are locked in unless, and the code section provides this, not in these words, but the concept is unless circumstances have changed significantly, the fee structure should be safe. The court will look up front to see, the court will say, is the fee structure that's disclosed, is it reasonable? And it buys a level of protection for the professional at issue. They can be revisited if there are unforeseen changes, but it really reduces the likelihood of having to fight later.
If a professional can get employed under 328, and it becomes much more difficult to challenge their fees down the road. Seems to me that most people would want to get employed that way. Are there problems with, or is it more difficult to get employed that way under 328?
That's a funny question. I haven't thought about it. I'm just looking at the code section right now.
Well, maybe I jump in. I can share an anecdote about that. I,
It's not
of course,
done
read
typically.
read the code, and I agree with what Matt said. I think it's much more favorable to be employed under 328, right? And the rules require, at least our local rules require in any application that it expressly say whether you're seeking employment under 327 or 328. And so I said, as a law firm that files Chapter 11 cases and is employed by debtors, I said, I want to be employed under 328. I want the judge to say on the front end that my hourly rate is reasonable. And so I started filing 328 employment applications. And I did this for probably a year, which, I'm not a high volume shop on the debtor side. And so, that's half a dozen or 3 or 4 cases. I can't recall how many. And all of a sudden, I got a call from the office of the U.S. trustee. And the U.S. trustee said, why the heck are you seeking to be employed under 328? You're a law firm. And I said, well, I read the code. I think it makes sense. I want to have my hourly rate pre-approved. And the U.S. trustee's office essentially said that if you're general bankruptcy counsel for the debtor, at least in our district, you cannot be employed under 328. They did not cite me to any provision of the bankruptcy code. It's really just U.S. trustee policy, as far as I can tell, and they frown on that in the sense that I think they view 328 as almost exclusively being available to professionals that seek a commission-based fee or a percentage, percentage-based contingency fee, for example, that sort of thing. I think any hourly rate professional, they're going to push back, although I see nothing in the code that would otherwise prohibit it.
You mentioned something that I think is interesting there, Doug, and that is U.S. trustee policy. And I know that turning away from 328 for a minute, I know Matt has run into some U.S. trustee policy-based issues in connection with disinterestedness. So I'm going to use this as a chance to flip all the way over to slide 28. And Matt, maybe you could just talk to us for a minute about retainers in a Chapter 11, insider versus this the source of funds. What are some of the U.S. trustees' issues there?
So before jumping into that, I want to go back to one thing that Jonathan said about the 328 approval. When they're reviewing that later, it's, whether there were significant developments in the case. And I think one caveat is that significant developments that were unforeseeable at the beginning of the case. And that's not the exact language from the code, but basically it's got to be something changed that we couldn't have contemplated was going to change. So we had a case one time where we were employed on a contingency. I got a 328 approval on a contingency, and then it settled relatively quickly for a large amount of money. And we said, great, we just made a big fat fee on something we didn't really have to litigate too much. And the bankruptcy judge tried to cut the fee back down. And we argued, look, Judge, the code says it's unforeseeable at the time that the fee was approved. It's always foreseeable that a case will settle and could settle for an amount, nearly what we're actually asking for. So you can't tell me that, and we prevailed. The judge ultimately allowed the fee But that's the key, is it's got to be something changed, and you couldn't have foreseen that change at the beginning of the case when they approved the fee. So I think
All the more
there's that
reason why
caveat.
people would want to get approved under 328 if at all possible, but I know the
Yeah.
U.S. trustee puts up a stink.
And my experience is the same as Doug's. The UST doesn't like it, and in our district, some of the judges historically haven't liked it either, except in a contingency scenario. And even in a contingency scenario, if it's like a preference claim that you're going to be employed for, and that you're seeking a contingency fee on, I've had judges say, this is a really simple preference claim. No, I'm not going to give you a contingency fee. Do it hourly. And so, okay.
Interesting.
Anyway, on the retainer side, so my practice always is the debtor pays my retainer. If they have to get the funds from one of the insiders or they're borrowing it from somewhere else, okay, but the money's going into the debtor's account and then they're paying me. Then the issue always is, okay, was that a loan from the insider or was it a contribution from the insider? And so you gotta have that conversation, because if it's a loan and they're basically borrowing money to pay your retainer, the US trustee doesn't necessarily like that. And it becomes a disclosure issue too in your declaration in support of the application to employ, that, hey, look, this is where the money came from to pay our retainer. And then there's always a sort of a split between the work you do up until the petition is actually filed, and then the work you do post petition. So we always do an invoice the day that the petition is filed for all the pre-petition work and time, and we pull that out of the retainer that day. So I don't have anything that's sort of hanging out there as pre-petition work that I'm trying to get compensation for later. And then, of course, post-petition, you've got all the rules on how often you can seek a compensation request. But we
if
try and have that firm line.
you talked about getting the money into the debtor, if that isn't practical, right? Are there issues with a retainer coming from a third party?
Yes, in my view, they're more disclosure issues than like prohibition on employment issues, right? So as long as I disclose, hey, look, we got paid a retainer of $100,000 and it came from this guy, then I think you're still going to be approved to be employed. Question may be, okay, how's the debtor treating that? Was it a loan? Was it an advance from a secured creditor? I've had secured creditors that advance funds on the loans to fund the retainers for professionals in Chapter 11 cases, because they realize that's where the case needs to go, and that's the only source of money the debtor's got to pay those retainers. So it's a disclosure issue. You need to tell people where the money came from, but it's not necessarily going to prohibit your employment.
And I think as we get deeper into this conversation, that topic is going to come up over and over again. Disclosure, disclosure, disclosure. I cut somebody off, and Doug or John, I'm not sure which one of you it was. I apologize.
Don't apologize.
Who was going to jump in?
I was. I was just gonna put a sort of an underscore something Matt said. So the scenario where the senior secured lender funds the retainer, whether directly or indirectly through the debtor, that's common in my experience, because often the debtor doesn't have the money. And the other in stark contrast, when the debtor's principals or the debtor's principal funds the retainer, it's a disclosure issue either way. As a practical matter, at least in my experience, it's courts don't really, what's the expression, bat an eyebrow when the money's coming from the secured lender. When the money is coming from the owner or owners of the debtor, and debtor's counsel takes instruction from the debtor, and the debtor is run by the same people that paid the retainer, and often the owner or owners of the debtor may be ultimately personally liable, or, based on a variety of circumstances, easiest, just by example, receipt of a fraudulent transfer. They took money out of the company, before bankruptcy as a dividend, and, they shouldn't have, blah, 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 blah. So you see the point, the tension, the natural tension, because um, a court and other parties' interest might reasonably ask, how can you um, represent, how do you separate your duty to the debtor from the fact that the human being, or, a fund or whatever that runs the debtor, controls the debtor, might be a target? How do you, I mean, doesn't that put you in a conflict position? And that's the hairier situation.
And that is a hairy situation. I wonder if it is simply limited, though, to when the new person or the insider funds a retainer. I mean, if they're going to be the subject of avoidance or a fraudulent transfer claim, whether they funded the retainer or not, there's still going to be a potential conflict. And I think we're going to come back and maybe we can talk about that, because there are a bunch of issues that potentially surround that just have to be dealt with in one way or another in connection with a Chapter 11. But because John and Matt talked about, this issue with a secured creditor funding the retainer. I guess I'm going to turn to Doug, and Doug, I'm going to twist that just a little bit, okay? And I'm going to say litigation funding has become very popular recently over the last, I don't know. We'll ask John in a few minutes because he does a lot in that space. But over the last, say, 10 years, um, uh, litigation funding's become a real thing. Uh, if we're dealing with a litigation funder and Chapter 11, um, can you talk about the potential issues associated with a retainer coming from a litigation funder?
Yeah, so there's kind of two aspects to it, in the sense that everything in bankruptcy is pre-petition or post-petition. The most important date is the date that the petition is filed, right? And I think it's worth pointing out that kind of the best practice post-petition, and or sorry, pre-petition, which you have to have a pre-petition retainer. No law firm's going to file a bankruptcy unless that money's not sitting free and clear in their client trust account as a pre-petition retainer. So pre-petition, really the best practice, and this is, the one take-home point I would say to anybody seeking to be debtor's counsel or a debtor's professional, is just get your money from the debtor. So if it's a check, it's coming from the debtor, and the debtor's, it comes from the debtor's account. If it's a wire, it's a wire transfer from the debtor. This shouldn't be that hard in the sense that at some level, as long as the money comes from the debtor, how the debtor got that money is almost not your problem. It can be in nuanced issues, but if your money comes from the debtor and your agreements with the debtor, then you're in pretty good shape as the debtor's professional. Why does this third party, funding coming from other parties, whether it be the secured creditor, whether it be litigation funding, whether it be the debtor's principal, why does that come up, right? Well, often before a debtor files, things are pretty grim at the debtor's situation. Creditors are levying bank accounts. Maybe there's been a freeze put in on the debtor's bank account. And so some third party, whether it's a commercial litigation funding entity, whether it's the secured creditor, whether it's the debtor's principal, somebody says, we got to file and we'll pay for it. And they wire you as the debtor's lawyer the money. And that's where the issue comes up. I know down here, we have one judge in the central district that's sort of seems to be on a warpath with lawyers getting money from anybody but the debtor. But it ends up being
Is
a
that Judge
disclosure issue.
Basin?
That's
Doug?
Judge Basin. That's right. And I have an issue that, I mean, you can tell war stories about why this matters, but in one instance, one case where I was a trustee, debtor's counsel received a $25,000 retainer from somebody, the debtor's vice president or somebody, and directly from them. And if you take things, your take home point is disclose. If she had disclosed it properly, it probably wouldn't have been an issue. But they prevaricated all over as to whether it was a loan, whether it was a contribution to equity, because they kind of were making it up as they went along. And they said it was all sorts of things. At the end of the day, the judge said, the case got dismissed. But before the case was dismissed, the counsel could kind of see that it was being dismissed, and counsel wired the money back, not to the debtor, but to the party that sent her the money. And I told Judge Basin, I said, I don't know if I think that's a violation of the automatic stay. And in fact, Judge Basin issued an OSC and ultimately held that it was a violation of the automatic stay, and ordered the party that had funded the funds, as well as the law firm, to pay and disgorge. At that point, with attorney's fees, it was over $54,000. And so that's, it's kind of it's now on appeal. So we'll see where that goes. Her arguments on appeal, the lawyer's arguments on appeal, is that, look, I have state bar duties to return the money to whom I got it from, right? But that just highlights the problem with getting it from somebody else. Even if I don't think that's going to carry weight, it certainly didn't carry weight with Judge Basin. But even if that's the case, that just serves to highlight the potential conflict here when you get money from anybody who's not your client. Now, post-petition, talking about litigation funding, post-petition, I think you're in a lot better of a situation because, any arrangement, litigation funding type arrangement, post-petition would be outside of the ordinary course. You would want to get approval of that arrangement, and sort of whatever that arrangement is, if it has the judge's stamp of approval and blessing, then you're not going to get in trouble for it, right? So it's when you try to do something pre-petition that might raise eyebrows post-petition that you get in trouble. And so my hammer to people, the point I'm going to hammer home is, before you file a bankruptcy, get your pre-petition retainer from the debtor. Whatever the debtor's arrangements to get the money, that's fine. That'll be what it'll be. But get your money from the debtor. And I, going back to John's experience, I would expect, or at least the instances I've seen, when a secured creditor funds a retainer, they send that to the debtor, and it's an advance on their loan, and then the debtor wires it to counsel. I certainly wouldn't recommend that the secured creditor wire the money directly to the debtor's proposed bankruptcy lawyer, although you have more experience in that field than I do.
Okay, so your point is, get the money from the debtor, and if there's going to be litigation funding, perhaps get it after the bankruptcy case kicks off, because you can get a judge's blessing. John, I'm going to break one of the rules that I laid out at the beginning, where I said this isn't an infomercial, and I'm going to say your bio says you do a lot of representation in the litigation funding field. Do you have anything? What's your view of if a debtor's going to get litigation funding? When does that happen, and what is the bankruptcy overlay that you'd want to see from a litigation funder lawyer?
So, first of all, the way we've been talking about the subject up until now, for the last 5 minutes or so, would conceivably give the audience the impression that a litigation funder might fund the retainer for the general bankruptcy work of the case, as opposed to a specific, litigation of the debtor. And it happens. I mean, it is possible that because the litigation, the lawsuit in question is so valuable, but the company, for whatever reason, must file a bankruptcy. It's certainly possible that a funder would fund sort of a general retainer for debtors counsel. But what you typically see is you don't typically see that. What you typically see sometime after the filing, it's certainly usually after the filing, and most commonly perhaps after confirmation, a funder comes in to fund specific litigation. The debtor has a cause of action it wants to pursue against the plaintiff or against a defendant or defendants. So that's the more common scenario. And if it's pre-confirmation, then the matter has to be brought by motion, and you get into some sticky the issues, along with the specific issues that arise, non-generically. The generic issues have to do with disclosure, because the litigation funding agreement is commonly, universally, confidential, and funders don't like to reveal the economic terms of that. So there's a natural tension in, bankruptcy court between, the disclose, and where the funders are coming from. Post confirmation, my experience is that the broad authority that liquidating trustees, and whatever they're called, liquidating trustees or post confirmation estates, are given under the trust agreement or similar document. It's broad enough, even if it doesn't say it specifically, to empower the liquidating trustee to enter into a funding agreement without having to go back to court. But I guess that can be an open question depending on where you are.
Okay. So, I mean, just to maybe try to tie this all back, and John, I appreciate that, the distinction that you laid out for us, but, litigation funding typically is not for a bankruptcy case, but for a piece of litigation. But that simply ties back, at least in my mind, to this whole idea that money coming from a source that is not the debtor's own bank account creates all sorts of potential conflicts for the law firm representing the debtor, and there are reasons why you wouldn't want to try to get it another way. Matt, I'm going to flip over to you, and perhaps one last potential conflict place before we really get into what does an application require, and how do we get the nuts and bolts of this thing nailed down. Personal guarantees, because that's a whole nother potential issue for debtors counsel. And I know you've had some potential or run-ins with your U.S. trustee's office on an insider guarantee. Can you talk about the problems you've had, and the reasons why you want a guarantee and where it goes?
Yeah, and I'll do it in reverse order of what you just said. So the reasons why we
Okay.
want them, a lot of the cases we file are small business cases where you've got, either a single owner or generally less than 10 owners in the company. And historically, many of those cases end up either getting dismissed or converted to a Chapter 7 case if they, for whatever reason, can't survive. And so especially when it gets converted to a Chapter 7 case, then we're stuck in the case as the debtor's attorneys, having to do a whole bunch of work in the Chapter 7 context that we're not getting paid for at all. because the estate can't pay us. And the debtor doesn't have any money left, they're getting liquidated. So we've tried to address that by putting in some personal guarantees by the company owners of any and all fees that are incurred even after conversion of a case to Chapter 7. And so far, our U.S. trustee has objected to that approach nearly every single time we've done it. The first hurdle we've kind of run into, which has caused me to back off a little bit, is if the company owner is also a creditor of the debtor, so they loaned money to help keep them afloat. That I think is a fact that I don't necessarily like. We don't have a good decision from our bankruptcy judge on whether personal guarantees are even okay. And so I want the perfect case where I don't have any wrinkles at all, where I can say, look, judge, they're not a creditor, they're the company owner, they're pushing to have the Chapter 11 done, but I want a guarantee from them, yay or nay, thumbs up or thumbs down. And so the conflicts the UST has identified is one, that they're a creditor of the debtor already. Secondly, that, if they're going to potentially be on the hook for the fees incurred in a Chapter 7 case, that might otherwise influence their decision on behalf of the debtor to seek conversion or consent to conversion to Chapter 7. And that's a conflict that they don't like either. Like I said, there isn't any cases from our district. As far as I know, there may not even be any cases in the circuit, but there are cases from other bankruptcy courts around the country that go both ways. Some of them say personal guarantees are fine, some of them say personal guarantees aren't fine. So it's one of those, that's why I gotta push it in our district and get a decision, so we at least know whether we can keep doing it or not.
So and there are cases going each way all over the country.
Yeah.
And if you think you want to try to get one, you better take a look at your at your local case law.
Yeah.
Doug, you mentioned a little while ago, I think it was you, one of you three mentioned a little while ago that there are certain ordinary course individuals that may not have to file an application to get employed. Can you give us just a 50,000 foot version of what an ordinary course professional is? And then we're going to get into the meat of the application to get approved.
Yeah, I think for in layman's terms, an ordinary course professional is a professional, going back to the definitions we talked about, lawyer, accountant, architect, other, whose involvement is not material to the case, basically. And what does that mean from a practical perspective? When you have a small business case, typically, at least I would never try to say that any lawyer or accountant is an ordinary course professional, and I do that because I think I get pushback from the U.S. trustee on that. When you have a larger case that has, you ask them how many lawyers do you employ, and they send you an Excel sheet, right? So they have 15 law firms, 15 accounting firms that do various things of their business. Well, then you usually have a pretty good shot of saying, look, in the grand scheme of things, these lawyers are ordinary course professionals, and you file an ordinary course professionals motion to get approval. Remember back to the anecdote that was shared by Matt, I believe, about the litigation trying, the U.S. trustee said they didn't have to file an employment application, and then the case got a Chapter 11 trustee got appointed, and now the Chapter 11 trustee is trying to get them to disgorge their fees that they received, right? So every time I think of professionals and ordinary course professional, I file a motion for approval of ordinary course professionals, and I disclose what they are, how much they bill, how much they're expected to bill, and I get an order approving the ordinary course professionals' employment. That way, if someone disagrees later on, I actually have a court order that allows them their fees, right? So
you may not have to, but it's always safest to actually get somebody, get a
right.
court order that
I don't
says,
think I
hey,
would
you're good to
ever
go.
send an email or tell my client that you can go ahead and pay a professional in a bankruptcy case uh, as an ordinary course professional without filing an ordinary course professional's motion and getting that approved, because there's just too much risk. Now, that would cover any outside professional, meaning, you know, a lawyer, architect, or whatnot that has you know, that is an outside firm. What about this issue of the, you know, a company may have an in-house accountant or an in-house lawyer that is just on payroll, right? And in those instances, in my experience and view, you would not have to file an ordinary course professionals motion. You can just continue to pay them as you know, proceed through chapter 11, because they are employees of the firm. They're W-2 employees, and you're not going to get in trouble for that.
That makes sense. John, you want to walk us through the application process? What is required? We're going to look at slide 17.
Yeah, it starts, one should start with bankruptcy rule 2014. And 2014 delineates what you're supposed to do. The debtor in possession files the application. It's got to be accompanied by a verified statement, and the verified statement of the professional. The So it's the application of the debtor, but it's the verified statement of the professional, and the conflict check that we all do if we represent debtors, for example. We turn the results of that conflict check into the meat of the verified statement, because the verified statement basically sets out all of the connections that so if I'm debtor's counsel, all the connections that my law firm, anyone at my firm, has to anybody we ran a search on, and the parties we run a search on include, the debtors, its affiliates, and basically all of its creditors. And there's rules of reason, right? If we're representing a company with 10,000 customers who might be creditors because they're owed refunds, we probably don't search 10,000 customers, but we explain very clearly what we did and what we didn't do in terms of the search, and then we present the results of the search. If someone thinks we didn't search well enough, then our first response is, okay, well, we'll go, maybe we'll go search them. But you want to be clear about who you search to give somebody the opportunity to say, I think you should search this class of of entities that you didn't search. That's kind of it. It's all about being transparent and complying with the very clearly set out requirements of the statute.
So once again, disclose what you're doing.
Yep.
Matt, let's turn to slide 18. You want to talk about specifically what the application has to set out, and we'll talk about the verified statement in a minute.
Yeah, as John said, the application is signed by the debtor in possession, not by the professional. In the application, you got to explain basically why you need the professional, what they're being hired for, who they are, why you selected that professional, what they're being hired to do, what the proposed compensation is. If it's a 328 application, I think you want to include information about, why you're making a 328 request instead of a 327, or in connection with the 327. And then usually we'll have some reference to the professional's connections, but it's generally just professional's connections are outlined in their verified statement that's attached herewith, or something like that. So we don't restate all the connections in the application itself. I will say too, in big cases, there's some additional information that have to be included in the application. Big cases meaning ones with more than 50 million in assets and liabilities. The debtor's application also has to explain really two things: the process they use to select that professional. So not just why did you select this person, but what was the process? Were there other people you looked at? That sort of thing. And what process the debtor's putting in place to help manage fees and expenses in those big cases. So that's what goes in the application itself.
Okay. Doug, the application requires descriptions of a bunch of stuff. Briefly, how much detail is really required?
Well, I would say it's from the law firm's perspective, it really is a sliding scale, and the sliding scale is to some extent how much money are you going to perhaps earn and want to make on this case, right? Um, Employment applications and then fee applications are, in bankruptcy world, probably the most important things that we as legal professionals will file with the court, because that's how we get paid. And if there's any issue that there was not sufficient disclosure, the risk falls on the law firm or the professional's firm that they may at some point not get paid for their work that they do in the case. So I always err on the side of more detailed descriptions, especially if it comes to I guess what I would call like a potential conflict or a potential connection. So, say I'm looking at something and I realize, that I go golfing with the judge's law clerk every Friday, right? Am I going to put something in my employment application that says, I'm an occasional, I am a professional acquaintance of the law clerk? Or am I going to say that I have regular activities with the law clerk? I mean, right, you don't want to look like you're hiding something. And so I just err in the side of over disclosure. If I, for example, maybe my firm represents a bank in matters unrelated to the bankruptcy case, I'm going to say exactly that. I'm going to say we represent this bank. I'm going to say it's in matters completely unrelated to this case. I might even say how much of a percentage is the bank's business for my firm, right? To kind of show that this bank is not a major client. I wouldn't do anything untoward in this case just to make my bank client happy.
So John, Doug's starting to roll into some of the stuff that probably ought to be in a verified statement from the professional, with the point, I think, that disclose, disclose, disclose. Do you have anything else you want to add about what ought to be in a verified statement?
Well,
Is that a maybe? I'm not sure.
yeah, it's a maybe. So,
Okay.
so first of all, the example of the law clerk is an interesting example, because if you look at the specific parties that need to be disclosed, if you look at 2014 A2, it has a list of it says the applicant must state specific facts showing, to the best of applicant's knowledge, all the person's connections with debtors, creditors, blah, 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 blah. It says United States trustee and any person employed in the United States trustee's office. It doesn't say anything about the court.
Which is an interesting thing, isn't it?
It is. Nonetheless, I agree. I would also, I would absolutely disclose it. In fact, I'd have sort of a working, and that's not something you would disclose on a case by case basis, probably, right? Let's say you're a shareholder of a notice and claims agent that might be used, or an auctioneer that might be used, or an auctioneer that might be used is a client of the firm, and it only might be used, and you're not a shareholder, it's just a client. There, you don't get dinged for being overly inclusive. And so there are certain disclosures depending on, who your relationships are as a professional, that you might always want to include just as sort of a standard boilerplate additional disclosure. Kind of like when we give notice, I think this is true everywhere. When we give notice of a typical motion in bankruptcy court, or a motion, pardon me, that has to go to like all creditors, we always include like the taxing authority, the IRS. We don't need to like think, oh, this is a special case where I need to include them. You always include them. So depending on what your situation is as a professional, there might be certain disclosures you always want to make, including your golfing buddy.
Well, and it goes to the disinterestedness too, right? So that statement swears that you are disinterested, right? But if you look at the definition of 101, it's a very broad thing. It says does not have an interest materially adverse to the interest of the estate or any class of creditors by way of a direct or indirect relationship, interest in the debtor, or for any other reason. And I guess when I sign something under penalty of perjury, I don't want people to question my judgment call. And so I say, I think I'm disinterested, but you may think differently because of this relationship or the other relationship or what have you.
I agree.
And I know we're running up against the end of the hour, but I want to bring back real quick one point that Matt made tangentially, and it goes back to why Doug and John and Matt have repeatedly said disclose whatever you find that comes up in connection with your search, and as you're trying to get employed, if you have even the smallest question, disclose it. And that is, and I'll just throw it out to all three of you. What happens if you don't disclose something and it gets brought up later? Are you going to get paid as debtors counsel? Who wants
Maybe
to
not.
know? I mean, because I see
Yeah,
Jonathan's eyes. John's eyes got really big. He's like, I know the answer to this one.
Yeah.
The answer is it depends.
Now,
It
there's a
depends.
real risk.
If it was inadvertent, if it was understandable, if it caused no harm,
Yeah.
then
And
yeah,
how quickly did you disclose it? Like once you realized, hey, there's this other issue, did you sit on it for a year before you're like, oh yeah, Judge, by the way, I sleep with your law clerk every night. That's
if
going to
the
be an issue, right? But or maybe I play golf with your law clerk every week is a better example. So if you disclose it as soon as it comes up and it's brought to your attention, that goes a long way, I think, than if you sit on it for too long.
Well, and then
if
there's
all
the
those
go ahead.
I'm sorry, if all those factors are in your favor, you may get a pass, but they could all be in your favor and you still may not get a pass.
Yeah.
Right, but there's sort of two aspects to how you get paid, right? And that's why disclosure is so important. One, if you disclose everything, maybe likely the U.S. tree or the judge is going to agree with you, and they're going to say, "Great, the judge is going to approve the employment application." There might be an instance where the judge does not approve the employment application, like say the golfing with the law clerk example. As long as you disclose it in your application, you can kind of keep working. And then at some point, the judge is going to say, I'm not going to allow you to do this. I think you're not disinterested. Well, if it was disclosed properly, you're going to have at least an argument to get paid under a quantum merit or other theory for the work you did and that benefited the estate. If it's not disclosed and it comes out later, then you're not going to have that argument, and you're really sitting there having worked a lot in the Chapter 11 case and facing the real potential of getting nothing for your efforts.
And the last thing I'll point out, it may happen long after that case is closed, that someone comes in and says, "Hey, Judge, by the way, there was this disclosure issue. There's a famous bankruptcy issue going on in, I think, the Eastern District of Texas, maybe Southern District of Texas.
Southern District of Texas right
Southern
now, where
District of Texas, where
it's
they're disgorging like 23 million in fees over 40 different cases, many of which are closed and done long ago.
right.
So
And
it's not like you can't just sort of feel like you're sitting tight. Once the case is closed, you're like, okay, I'm safe. You may not be.
I think that's very good point, and it also goes to the detailedness of the descriptions. I mean, I looked into that case quite a bit, and that was a case where the judge was actually, as you said, as you noted, was actually sleeping with one of the local council lawyers. The disclosures said something like they were professional acquaintances, or I forget the name, how it was said, but it said they knew each other, right? They knew each other, but what they left out was that they had a much more intimate relationship going on. And, they probably left that out for obvious reasons of embarrassment and whatnot, but that was material.
Uh, Matt, Doug, John, thank you guys for participating today. To our audience, we appreciate you being here with us. There is a bunch of information in the slide deck that we just ran out of time. We were not able to cover. I encourage you to take a look at it, including information about employment as committee counsel, employment of a chief restructuring officer, other folks that are often involved in Chapter 11 cases. We appreciate your time. We invite you to join us for the third session of this second round of the nuts and bolts sections, which will be dealing with releases. Thank you and goodbye.
Thank you.
Thanks.
Thank you.